For the past couple of months, banks have been giving moratorium to individuals and companies to ease one's debt repayment as a form of a resuscitation exercise. Now that the moratorium period is coming to an end, companies can consider protection afforded in the Companies Act 2016, such as Section 368, 398, and 410, for a moratorium on debts owing not just to banks, but to all your other creditors as well. For today's video, we'll talk about Section 368. To encourage us to make more videos like this, please like, share, and subscribe. We will really appreciate it. Thank you. In case you are unaware, Section 368 of the Companies Act 2016 allows a distressed company to apply for an order to restrain further proceedings in any action or proceedings taken against the company. In other words, the court can grant an order to protect the distressed company for a limited period of time from being sued or prevent any further action taken against it by its disgruntled creditors. This provides a breather to the distressed company to initiate a restructuring and repayment plan to all its debtors. Before the company is wound up, the company or any of its members or creditors can make an application to court for a restraining order pursuant to Section 368 of the Companies Act 2016. The court may grant a restraining order for a period not more than 3 months and extend it not more than 9 months, depending on whether the company has fulfilled the criteria set out in the Act and whether it is justified. Such order can restrain all proceedings taken against the company except proceedings initiated by the Registrar of the Securities Commission. The restraining order will also not cover proceedings taken against the guarantors of the company. Section 368 sets out certain criteria that needs to be fulfilled before such an order can be granted. Number 1. The court must be satisfied that there is a proposal for a scheme of compromise or arrangement between the company and its creditors or any class of creditors representing at least 1/2 in value of all the creditors. 2. The court must be satisfied that the restraining order is necessary to enable the company and its creditors to formalize the scheme of compromise or arrangement for the approval of the creditors or members under Section 366 of the Companies Act 2016. 3. Upon making the application, there must be a statement of particulars as to the affairs of the company made up to date not more than 3 days before the application is launched together with the application. And 4. The court will need to approve the person nominated as a director in the company by the majority of the creditors in the application. This director will act as a representative of the creditors, where he will have access to all information and accounts of the company and shall carry out the proposal for the schemes of compromise or arrangement. What goes in the proposal for the scheme of compromise or arrangement is important. It must be something that is feasible, legitimate, and related to how the company will pay off its debts. The scheme can include a proposal on how the company can raise funds within the specific period of time, a proposal to pay off the debts whether by installments or with a haircut, a proposal to introduce a white knight to the company, or a proposal to dispose certain assets in it. You just need to be creative in finding ways to restructure the company's debt. When dealing with the disposal of assets in the company, other than in the ordinary course of its business, whenever a restraining order is granted, the company must first obtain a permission from the court in doing so, failing which, such transaction shall be deemed void and every officer in the company shall be liable to imprisonment for a term not less than 5 years or a fine not exceeding 3 million ringgit or both. Section 368 can be a useful and important tool for companies who are considering to buy time in order to save the company. A year of immunity can change the tide for any companies who are genuine in coming up with a plan to restructure their debt.